Great. So we are recording. Good morning, everyone. Thank you for your patience this morning. My name is Kerrilee Auger, and I am the Skills Development Officer here at Women's Enterprise Center, working out of our Kelowna office. So before we get started, I just want to make sure everybody on WebEx this morning, if you look at the top right hand of your screen, you will see the icons for chat and Q&A. So if you want to highlight those, you will see the Q&A and chat windows appear on the right-hand side of your screen. So if you have any questions or anything as we're going through the content this morning, be sure to type those in there and we will address those for you in the Q&A at the end. As we do have everybody muted this morning on this webinar so that we avoid any of that background noise. So to get us started here, I'm just going to tell you a little bit about Women's Enterprise Center, and then I will hand it over to our panelists today. So Women's Enterprise Center, we are the leading business resource center for aspiring and established women business owners in BC. We provide business loans of up to $150,000, skills training, mentoring in both a peer group and one-to-one format, business advisory services, and resources from our offices located in Kelowna, Vancouver, and Victoria. Our passion is to empower entrepreneurs to their business success. We're a nonprofit organization funded by the federal government through Western Economic Diversification, and we're part of the Women's Enterprise Initiative, which includes similar organizations in Alberta, Saskatchewan, and Manitoba. So to learn more about WEC, our resources, and how we can help you, be sure to visit our website, womensenterprise.ca, and sign up for our e-news and e-blasts. So again, just that reminder, use those Q&A and chat boxes on the right-hand side of the screen for your questions today, so we can address those at the end. So our topic today is Introduction to Intellectual Property. We are pleased to be working with BLG, and this is one of the sessions that's part of their Driven by Women series. So today, building an intellectual property strategy is important for your business development. So we're going to cover the topics of what is IP, what are the common types of IP, why IP is valuable, and how to protect your IP. So this morning we are pleased to have Todd Keeler and Michael Damiani joining us from the BLG offices in Vancouver. Todd is a lawyer, lawyer and patent agent in both the Intellectual Property Group and Information Technology Group in Vancouver. He focuses his practice on IP law, particularly drafting and prosecution of patent applications in high-tech electrical, electronics, and the medical fields. Michael is a lawyer and patent agent in the Intellectual Property Group as well in Vancouver. He specializes in drafting and prosecuting patent applications in fields related to biotechnology, life sciences, pharmaceuticals, therapeutics, medical devices, chemistry, and oil and gas. There's many more things that these amazing gentlemen do, so thank you, Todd and Michael, for sharing your expertise with us today. And I will hand it over to you now as the presenter with the presentation. Here we go. So Michael and Todd, take it away, and please introduce yourself.
Great. Well, thank you for inviting us to present, and I don't think we have to go to, you provided a great introduction for us, so I guess we'll just jump right into it. Great. So what is intellectual property? So there are a few important types of intellectual property, or these are the most popular ones. So trademarks. Trademarks are words or phrases or logos associated with a particular product or service. Patents, which protect a new or improved product, process, or composition of matter. And so when people refer to inventions, they're usually talking about some kind of functionality, and that pertains to patents. Trade secrets, it's information that's proteced by a company, it's kept confidential, and it has some kind of commercial value to that company. Copyright protects very specific forms of literary and artistic works. Important software code would be protected under copyright. And industrial design, so you protect more of the appearance or aesthetic features of a product rather than utility. So for example, a lot of designers, if they come out with new, for example, we do a lot of industrial designs in the handbag industry, so if they've created some kind of distinctive design, they'll protect it with an industrial design. In the US, industrial designs are referred to as design patents. So generally, IP is know-how. So it includes all knowledge about a business and how it operates. So IP can also include things such as supplier lists and price lists, customer lists, and knowledge that may exist only within the head of key employees of a company. So it's quite broad, and there's lots of things to look at when you're, for example, buying or selling a business. In addition to these tangible assets and registered IP, if you are looking to buy a business, you want to make sure that you acquire the know-how related to that business. And why should you protect IP? So these are four of the main reasons why you want to protect IP. So you want to protect your market share. You want to protect a key technology or feature that your company relies on. You might also want to create barriers for entry for competitors. And sometimes people just protect their IP to make money, not to actually use or realize their intellectual property, but just to potentially license it out or sell it. So a couple questions that we ask clients when they're kind of coming up with an IP strategy is, one of the questions is, what do you most want to be able to prevent your competitors from doing? And if they do something, what hurts you the most? Because generally, if you do have a successful business, somebody's going to want to copy it. And so intellectual property prevents barriers from them just basically copying and trading on the goodwill that you've built up with your intellectual property. So the first type of intellectual property we'll go over is our trademarks. So these are the typical different types of trademarks. So the word, a symbol, the Mercedes-Benz symbol, a slogan, like He's Just Do It, and packaging, for example, the Hershey Kisses. But a trademark, what it does, it associates a product or service with a source, right? So every time that you see, for example, that Mercedes-Benz symbol, you're going to associate with the Mercedes-Benz company. There are also some non-traditional types of marks. Just note that these aren't available in all jurisdictions, but for example, sound, so the MGM lion, growling, I guess, is protected. So Tiffany's has a trademark on that distinctive color. I don't know, it's only blue to me, but I don't know whatever that color is. The fragrance, this is interesting. These are threads that smell. A design, for example, the arches on McDonald's. Even Apple, how the design of most of their stores, they have protection on that. And motion, this is the Lamborghini sliding, the doors swinging up. So one key distinction between a trademark and a trade name or business name. So generally, if you're referring to it as a noun, it's a trade name. So the Coca-Cola company is a trade name. But if it's an adjective, so it's describing a noun or service, it could be a trademark. Now you could use a trade name and also have it a trademark, and vice versa. Like you can have one name that is both your trade name and trademark. So an example for the distinction between trade name and trademark would be, I'm going to go get traveler's checks from American Express. So in that context, American Express is referred to as a noun, and it's a trade name. It's a place, right? Identifies a company. But if you were to use it as, I'm going to go get my American Express traveler's checks here, you're now identifying where those checks come from, and so therefore it's used as a trademark. So the functions of a trademark, indicates source or origin of goods or services. It assures consumers of the quality of goods bearing the mark. So, for example, I'm a big fan of Purdy's chocolate. So every time I see chocolate that has the mark Purdy's on it, I assume a certain quality. That quality is different, for example, if I see a package with M&M brand on it. I'm not saying that that's a lesser quality, but it's just a different quality that I associate with that mark. And then also another function of trademarks is to create business goodwill and brand awareness. So if you're looking to secure a trademark, there are 3 general steps. One is to select a trademark. The second is to clear it, to make sure that nobody else has a confusing mark, or a mark that's confusing to yours. And then 3, to protect it, is to, if you decide to register it, how to go about protecting your mark, how it's used in the public. So selection is very important. So this is a great slide to show a scale of distinctiveness of a mark. So generally on the right, the more distinctive a mark is, the more protection you're going to get. So at the very right, Haagen-Dazs. Another examples are, for example, Google. So Google is a made-up word, like Instagram, another made-up word. These words didn't exist before they were trademarked. So those are the most distinctive because they're made up. Arbitrary, for example, Apple. I mean, Apple is quite popular now, and everyone associates that logo and the name with the technology company. But if you can go back to when Apple was first starting out, no one would really associate Apple with a technology company. So it was quite arbitrary. Suggestive, Burger King, it kind of suggests what it does or what's involved, but still the consumer has to use their imagination a little bit. So now the less distinctive is a descriptive mark, so American Airlines. So right away when you read American Airlines, you know it's an American airline company. And then the very end is generic. So you won't be able to get trademark protection for a generic mark. So generally, the more distinctive the mark is, it'll take more money and more effort for you to educate the public about what that mark is associated with. But once you do, it's far more protective, and you get much greater level of legal protection than you do a more descriptive mark. For example, American Airlines, where you wouldn't necessarily have to spend that much money educating the public about what your mark represents. So the second step is to clear the mark. So there's international clearing searches. Most countries have their own specific searches. You'd want to do country-specific searches. Most countries have their own intellectual property office website, so you can do searches there. Usually when clients come up to us about registering a trademark, we ask that they do their own Google searches and then also go to that country-specific intellectual property office website and type in the trademark that they want to register and see if anyone else has that mark registered, and whether that mark is registered and associated with the same types of services that they want to associate their mark with. And then we also want local expertise, because sometimes we don't know how that mark might be translated or how interpreted in other languages. So you want, if you're going to register a trademark, you can either go through a single trademark office. There are some regional trademark systems and also a Madrid protocol system, but generally you're going to have to file a different trademark application into every country that you want that trademark protection. So rights for trademarks you can get rights obtained by registration or by use. So, for example, you don't necessarily have to register a trademark to get protection for that trademark. Just by using it in the public and building up some kind of reputation, you're going to get rights to that trademark. The downside is that, for example, if you're a BC company and you've built up this reputation based on this trademark that you're using in BC, and say a Montreal company is offering the same types of services in Montreal, and they're using a very similar trademark, you might not be able to stop them unless you prove that you have a reputation in Montreal, and that is quite difficult and very expensive to do. It's literally you have to hire people with questionnaires to go out on the street and ask people in the public about whether they've heard about your brand in BC. So on the flip side, the reason why people would alternatively want to register their mark is that it gives them national enforcement, for example, in Canada. So even if you register a mark in Canada, you get protection across Canada, even if you're not using your mark in, for example, Montreal at this time. And also there's a presumptive right that you have, and so therefore it's cheaper to enforce. You don't have to go out and get questionnaires from people in Montreal. So this is just kind of a recap for protection. So you want to, if you're registering a trademark, you want to make sure it meets the legal requirements. So for example, as I mentioned before, you want to make sure that's not generic. There's also, in Canada, we also have laws that you can't register, it can't be immoral, the mark that you're trying to register. So you'd want to, again, do the searches to make sure that there's no identical or confusingly similar marks that are already registered. And then the application process. So you'd submit a trademark application in each trademark office of the countries that you wish to get protection. So using a trademark. So if you have registered your trademark, you should always identify it with this R with a circle around it, or you can use this phrase, X is a trademark service of the company. If your trademark is not registered, you would use the TM, and then this just kind of puts the public on notice that someone has asserted rights for this trademark. There are ways to lose your trademark rights. For example, improper use, failure to police, failure to renew your trademark application. In Canada, your registered trademark, you have to renew it every 15 years. If you stop using the trademark, you could lose it. And there's also, if you want to cancel it, you can do so. And if there's a business transaction or whatnot, if it's improper license or assignment of that trademark, it could be lost. So genericide. So once a trademark, not always a trademark. So it's always important to police third parties, unauthorized or improper use of your trademark. So in this graveyard here, these are examples of trademarks that lost their distinctiveness and lost their protection. And the reason is because the third parties weren't monitored sufficiently. For example, aspirin. People now refer to aspirin in a noun as something like, oh, grab me an aspirin, or I'll pop an aspirin. What aspirin, should have been doing was protecting it and making sure that whenever their aspirin was referred to in the public, it was used as an adjective. So, for example, an aspirin tablet or an aspirin medication. In the U.S., they lost protection, registration of the term aspirin, although aspirin is still registered in Canada. So these are some things that you can do to avoid genericide. So when you use your trademark in text, you want to potentially distinguish it from the surrounding text. So quotation marks, large size font, capital letters help, initial capitals works. Distinctive print, that might be a little bit small, but those Mercedes-Benz is shaded, or a color. And you always want to make sure you use R or TM where appropriate. So here's a good do's and don'ts. As I noted before, you want to make sure that you refer to your trademark as an adjective, not a noun, so a Kleenex tissue. You don't want to pluralize your mark, so it's two Dell computers, not two Dells. The mark is Dell, singular. You don't want to use it as possessive. You don't want to use it as a verb. So Xerox also lost its distinctiveness because people just referred to it used it as a verb. And you want to be consistent and use proper spelling. So if your mark is H and M, you don't want to use H and then the word and M with spaces between it. You want to be consistent with its use.
Okay, so we're moving on from trademarks. Now we're going to talk about patents, and just so everyone on the line knows, this is now Todd Keeler who's talking. That was Mike Damiani presenting on the trademark side. So on the patent side, we want to look at first, what is a patent? A patent is essentially a bundle of rights that is given to you by a government that protects an invention. An invention in the broadest sense of the word, can be considered any new or improved product, process, or composition of matter. What that means, we'll get into a little bit later. As Mike mentioned, on the trademark side, you can get some common law rights. If you're using a trademark, you might get some maybe more limited regional protection, but you do have some protection just by using your trademark. That's not the case on the patent side. There are no common law rights. You basically have to go through the process in a patent office and obtain patent rights for your invention, and if you don't do that, you can lose your rights, or basically, which means anyone else is free to use your invention, which brings us to our next point of what are those rights that you get. So you get a patent from a patent office. What does that actually mean? Well, we refer to the rights that are granted to you as negative rights, and what that means is you have the right to stop other people from making or using or selling your technology or your invention, but they don't necessarily convey you a right to use your patented technology. And that sounds a little abstract, but an example might help. And this comes up with the fact that most inventions that you see nowadays are some improvement on a product that already exists. And so what that means is that product that you're improving most likely has a patent or several patents associated with it. I'm looking at my smartphone right now, and I'm sure it has hundreds of different patents that cover it. If I come up with a new improved feature that I think could be incorporated into a smartphone, I file a patent on that, I get my patent protection. That doesn't give me the right to, in my garage now, start manufacturing iPhones, for example, that have my new feature in it, because there's a whole bunch of other patent owners who are out there that have patents that are, patents for technology that's already incorporated into an iPhone. So that's sort of a simple example of, just because you get a patent for something doesn't necessarily mean that you are just free to start manufacturing your product that incorporates that technology. This sort of picture on the bottom is to illustrate that one way you can think of a patent is it's sort of a transaction that happens between a government and an inventor. So the government is essentially transferring rights to you, and in return, what your end of the bargain is that you are going to disclose your technology publicly and make it available to other people. So let's take maybe a little closer look at that. So on the government's end, what are they giving you? Well, they're essentially giving you a monopoly. You have like I said, the right to exclude others from using your technology. It's sort of an exception to this open and free market economy that we have. It's a limited monopoly. You have 20 years, and essentially the idea is it gives you a head start over your competitors to reward you for the innovation that you put into this. But after 20 years from the date of your first filing, that's going to become, your technology is going to become public domain, and anybody is free to use your technology. And then, so on the inventor side, what do they have to do in return for that 20 years of protection? Is they have to disclose their invention in enough detail that would enable somebody who works in that technology space to be able to reproduce and use that invention. Similar to registration on the trademark side, patent protection is country specific. So if I was to think, okay, well, I live in Canada, so I'm going to file for a Canadian patent and I'm going to get that, that's not going to protect me in any other country other than Canada. Again, a U.S. patent is not going to be enforceable in Canada. So essentially, you have to think of what countries around the world you would want to prevent people from using your technology, your invention, and file for a patent in each of those countries. So like I said, there's no common law rights. If you want to get a patent, you have to go through a patent office and you have to follow their procedure for obtaining patent protection. And so what is that procedure, or what sort of requirements does a patent office going to use to evaluate your patent application and decide whether you should get a patent for your invention or not. The first one is that your invention must fit within a category that is commonly referred to as subject matter in the patent realm, but the subject matter of your patent application has to be an area that the Patent Office has identified as being patentable. Section 2 of the Canadian Patent Act has a very broad definition of what is patentable. It follows the similar wording to what was on the previous slide of a new product, process, composition of matter, or an improved product, process, or composition of matter. It's a very broad definition, but essentially when we're looking at what's patentable in Canada, it's sometimes useful to think maybe more in terms of what's not patentable. There's a whole body of case law that has determined certain subject matters that patent protection isn't available for. One of them that's listed here is a mere scientific principle or abstract theorem. So if you come up with, a new formula for something or some scientific principle, you're just not able to get a patent protection for that. It's deemed to be more of an abstract concept rather than a tangible invention. Some other examples in Canada, you can't get a patent for a higher life form. You can't get patent protection for, they say software per se, but there's ways to get around that in terms of, defining your invention, and if it's software based in terms of a method performed by a computer, but that could be a whole separate presentation on its own. The other requirement that's going to be looked at is novelty. So your invention must be new. Essentially, it just means that nobody else has done the exact same thing before and made it publicly available or it's been publicly disclosed. Something that a lot of new inventors that come to talk to us don't realize is that this concept of new or novelty has to be new in view of the company or the inventor's own disclosure. So if you say make an invention, you incorporate it into a product, you start selling the product, and then afterwards think, wow, I should maybe get a patent for this. We'll talk about this more in later slides, but you may have lost your rights there. Novelty generally, unless there's disclosure issues, generally isn't a big hurdle to get over if somebody hasn't done the exact same thing before. What's generally a little more nuanced or a difficult challenge is where myself and Mike's job as a patent agent, where a lot of our work lies is convincing the Patent Office that what the invention is not obvious in view of what's been done before. So that essentially means that the invention is not just a minor improvement of what's been done before, that would just be obvious to somebody, or some sort of obvious variation or some sort of obvious combination of, you've taken two different things that already existed and you just kind of stuck them together, and that would just be obvious to do, so you're not going to get a patent for that. Those are some of the arguments that we as patent agents face, and we have to come up with reasons why what it is that we're trying to get a patent for would not have been obvious. A useful metric or test to use to determine whether something is obvious or not is you look at that difference and you think, is there an advantage that's associated with that difference? So you're looking at what's been done before. Our improvement is this difference. Is there an advantage associated with that difference? And if so, then you can kind of construct an argument that it's not obvious, in that if it was obvious to make that difference and there's an improvement associated with it, then why wasn't anybody building it that way? That's kind of the logic behind most of an argument against an obviousness rejection in the Patent Office. The final requirement is that the invention has utility. Again, this is a fairly low bar bar to get over it. It essentially just means that the invention, as you described it in your patent application, does what you have described it to do. When to file a patent, I think I mentioned this a little bit before with regard to disclosure, but more generally, the patent process is very critical when it comes to deadlines. If you miss a deadline, it can be very unforgiving, and you may completely lose your rights. Some important dates that we've listed here is that generally how the process works is you would file an initial patent application in one country, and that will establish your priority date. So, for example, you might first file in Canada or the U.S. Once you've filed in one country, you have up to 12 months to file in other countries. And if you file within that 12 months, what you're able to do is claim priority back to that original filing, and essentially the Patent Office will treat your later filed application as if it was filed on the date of that earlier, what is known as the priority application, or that earlier filed application, with respect to what sort of prior art, meaning mainly previously filed patents and patent applications, that they will consider when looking at the previously discussed criteria for novelty and non-obviousness. And then, like I had said earlier, going back to this idea of disclosure, most countries in the world require that you get your patent application on file before you've made any sort of public disclosure. We'll talk a bit more about public disclosure in some future slides, but essentially for most countries in the world, if you've made your invention public, they take the view of the cat's out of the bag, and now it's no longer new, and you don't meet the requirement for patentability. There's a few countries in the world, I think Canada and the U.S. are probably the most notable. There's a few other, I think they're mainly Commonwealth countries that have some sort of grace period, but they essentially say, if you do make a public disclosure, we're going to give you a little bit of time, 12 months, in order to get your patent application on file. The important thing to remember, though, is that you, in Canada and the U.S., if you're relying on that grace period, you have to get your application on file 12 months from your earliest disclosure, rather than, so if that filing falls outside of that 12 months, even if you can claim priority back to an earlier application, it doesn't matter because that disclosure is still 12 months earlier, so you're outside that grace period. So that's sort of one exception to where priority that was discussed earlier might not help you. So 3 common mistakes that we see quite a bit that I'm going to discuss in a little bit more detail. One is public disclosure, which I've discussed a little bit before. The second issue is the issue of ownership and also inventorship. And then the third is not really understanding your competitive advantage. Some people just sort of rush off and file a patent application without really understanding why they need or why they think they need a patent application. We'll get into a little bit of that in a future slide. So public disclosure, as I mentioned before, the patent offices in most of countries around the world are very unforgiving. If you've made a public disclosure, you're going to lose your patent rights. Public disclosures can come in many different forms. You could post a description of your invention or a product on a website. You may distribute marketing materials. You may give presentations to investors where these investors haven't signed a non-disclosure agreement or some other document that restricts their ability to pass that information on. Research papers or articles is something we see a lot of in the academic world. An academic might rush off to publish a paper and then afterwards think, oh, maybe I should get a patent for this too, and they've lost a lot of their rights just by publishing that paper. Public disclosures may be written or oral, so I think that's an important distinction to keep in mind, that even just telling people about what your invention is and how it works can be a public disclosure. It's also irrelevant whether anyone actually has accessed your disclosure or not. What courts look at is whether access was possible. So an example is somebody might accidentally upload their engineering specs of their invention to their website. That could be publicly available, even if it's only up there for, say, an hour, and then they realize the mistake and pull it down. That can be, and they can prove that nobody actually accessed that on their website. There's case law out there where the courts have said it doesn't matter that nobody actually accessed it. The fact that they could possibly have accessed it is enough that that's a public disclosure. So some pretty significant consequences flow from that. So I think disclosure is always something, if you're considering getting patent protection for any inventions that you're developing, you always want to keep that confidential and not disclose it to anyone until you actually have something on file. Inventorship versus ownership. This is a common issue. I see it a lot in, I guess, an academic setting where on an academic paper, they might put the name of every single person in the research group, regardless of, you know, their involvement in the actual work that's being presented in that research paper. In the patent world, you have to be more specific. Inventorship is really anyone who's contributed to the inventive concept that's set out in the claims. Just very briefly, a patent application has a big, long description of exactly what the invention is, but at the end it has claims, which are essentially one-sentence statements that are really setting out the scope of protection of what that patent is going to cover. So there might be features that are in the description, but they're not in the claims, and so whoever came up with maybe those features, if their only contribution was that one feature and it doesn't make it into the claim, then they might not be an inventor on that patent application. But then, you know, that can change over time as, you know, you go through the negotiation with the patent office to try to get a patent issued. You might end up having to add that feature into your claims to meet those either novelty or obviousness requirements, at which point now that person who came up with the concept for that feature, which now is in the claim, would have to be included as an inventor. And I think the important point here is knowingly listing incorrect inventors is one way that your patent could later be held invalid. Essentially, the argument is that you're committing a fraud on the patent office by, you know, knowingly listing your inventors incorrectly. The other issue that we see is with ownership. So the patent office generally takes the view that the default view that the inventor is the first owner. But then, you know, how you get around that is you execute assignments, you have employees, you have it clearly set out in your employment agreement who's going to own that. And like I said, again, inventors is an ongoing process as the claims change. So understanding your competitive advantage, obtaining patent protection is expensive, and so you really want to make sure you understand why you're getting a patent and whether it's worth the cost, especially if you're filing in a whole bunch of different countries, it's going to be expensive. You want to know what your competitors are doing. You want to know how your competitors might try to work around your technology. So if you can file a patent application, but the protection you're going to get is so narrow that anyone could make just some minor tweaks to it, and now they don't fall within your claims, your patent isn't very valuable and probably not worth the cost that it's going to get that patent. You'd always want to do a prior search before filing if that's feasible. It's essentially going to give you an idea of what the scope of protection that you're going to get is. It's a broad concept, something that nobody has done before, and you're going to get protection for that, or are you really going to have to get quite narrow to the specific features that you've come up with and get very narrow protection, which then again is going to open the door for your competitors to just work around your technology, making the patent less valuable. I'm just going to move on in the interest of time here. You know, if you decide that maybe it's not worth the money, then you would need to think about what are maybe some alternatives. One alternative is you can just disclose what you've done. It's essentially going to give your invention away for free, but it's also going to prevent your competitors from getting a patent to that same technology that they've sort of independently developed. Another possible avenue might be to keep your invention as a secret if it's the type of technology that can be kept secret, and we're going to talk a little bit about trade secrets next, so I'm going to give this back over to Mike.
Okay. Yeah, so just generally in trade secrets, so how they arise, well, it's information that's not generally known to the public. It has some kind of economic benefit to its holder, the company usually, and it's subject to reasonable efforts to maintain its secrecy. So some examples of trade secrets are, so the most famous one is the secret recipe for Coca-Cola, client lists for sure, marketing plans, method of negotiating contracts. So these are all some examples. But another very popular type of trade secret is an algorithm. Generally, an algorithm on its own can't be protected by a patent, but so a lot of companies, especially in the financial world, protect their algorithms by trade secret. So trade secrets are not registered, unlike patents and trademarks. So trade secrets can be protected by and should be protected by confidentiality agreements, specific company procedures to keep that confidential information confidential. And they can only be enforced if someone has unlawfully obtained or disclosed confidential information. So, for example, if there's been an independent development by another party, you don't have any recourse against them. So generally employees, so if an employee leaves your company, they're allowed to take the skill and experience from the company to another, but not the information which is not made available to the public and is specific to that employee, to the previous employer. So that they're not allowed to take to their new employer. So the trade secret pros, one is that it's not available to the public, meaning used in the public after 20 years. It never gets disclosed to the public, and there's no 20-year limit like a patent. It's practical or impossible to reverse engineer, and it's much less resources are required than patent protection. The downsides are it has to be kept secret at all times, and as I mentioned before, all rights of the invention are lost on disclosure, and if it's independently developed and potentially patented by another company, it's completely blocked because trade secrets are kept confidential, they're not disclosed to the public, and therefore if another company comes up with the same idea and it is patentable and patents it, it's technically new because it hasn't been disclosed. I guess Todd will just talk a little bit about the last one, copyright.
Okay, I'm going to quickly talk about copyright and industrial design. These are sort of less common forms of intellectual property, so I'm just going to go through these quickly. As Mike mentioned at the beginning of the presentation, copyright protects works, is what the Copyright Act calls them, but essentially literary works, novels, books, even computer software, anything that's written down, dramatic works, artistic works, musical works. It also includes compilations. The copyright protects the expression of the ideas, not the ideas themselves. So, for example, a Shakespeare play, you couldn't just copy that play and make copies. Well, you probably could because copyright is expired, but something maybe more, a more modern novel or something, you can't copy that novel, but you could take the general plot and the general idea, and you could write your own novel, for example, and that wouldn't be infringing copyright. Copyright also includes what are called moral rights, which are the right of attribution or integrity, which are not assignable. So copyright first goes to the author and then maybe assigned to another person. But if you, for example, paint some sort of work of art, even if you sell it to somebody else, that person who buys it doesn't have the right to the right of attribution, so they can't say that they painted it themselves. They have to give you still as the artist credit, is an example of that. The term of copyright is quite long. It's generally 50 years from the end of the year in which the author dies. So if you created some sort of work early in your life, then copyright could potentially extend for quite a long time. There are other exceptions to that, but it's really not what we're getting into here. The criteria for copyright arising is there has to be some sort of originality. It's not copied. The courts would generally use a skill and judgment test. The work has to be fixed in some form. It actually, you have to actually create the work. It just can't be an idea in your head that you have. There has to be certain ownership for the copyright protection, so you have to be a citizen or resident of a treaty country. There's various treaties that are listed here. And like I said before, the first owner is generally the author, but this can be, the default position can be changed by if this was a copyright arose as part of an employment relation. And copyright is common law. You can register it. The registration process is fairly straightforward, but because copyright just arises as at the time you create the work, it's generally not something that people spend a lot of time registering. I think the only real reason to register would be if you're trying to enforce your copyright. I think in Canada there's a requirement that it then has to be registered, but you can always go back at a later time and register copyright. It's not like patent protection where you only have a very specific window in which you can register a patent or apply for a patent. And so that's it for copyright. I'm going to quickly do one slide on industrial design, and then we'll open the floor for questions if anyone has any questions. So industrial design, I think Mike had mentioned earlier, it generally covers the shape, the configuration, the pattern, some ornamental features of a finished article, like a product. It could be, glassware you see a lot of, or
Coke bottle.
Yeah, like the Coke bottle, or fabrics, or clothing, or bags, or shoes, or that sort of thing. It cannot consist of features that are dedicated solely to a utilitarian function. So it's not really, you can't really get around, say, instead of filing a patent, file an industrial design to protect the functional aspects of your product. It's really just for the design, the aesthetic look of your design. The term for industrial design is much shorter than other forms of intellectual property, so you get an initial term of 5 years from when your industrial design becomes registered, and then it's renewable for a further 5 years. That's in Canada. Other countries have different terms, but 10 years is pretty standard. Similar to patents, once you get your industrial design protection, you have the right to exclude others from making basically products that have that same design. And so that's it for our part of the presentation. If there are any questions that anyone has, we have a little bit of time. Again, we apologize for the late start this morning, but we do have a bit of time if anyone has questions.
Great. Thank you, Todd and Michael. It's Kerrilee here. We've had some questions coming in throughout your presentation this morning. So I'm going to go back to the topic of the IP. So one of the first questions came in is, can the IP be protected across countries? And this, I'm also going to tie in with a question received about trademark, asking if we do business in the U.S., example, Point Roberts, which is in proximity to our head office, our IP is unprotected unless we have also filed in the U.S. So maybe you can talk about the IP and the trademark, especially where a lot of our clients do have their businesses operating here in BC, but sell across the border.
Yeah, so the general rule is that you have to apply or register your intellectual property in each country that you want protection.
Okay.
Yeah, so that's the general rule. So if you are advertising your services or wares in the U.S. and U.S. is your marketplace, and you want protection, you don't want someone in the U.S. Registering as or using a similar trademark in the same field, you would want to register a U.S. trademark as well as a Canadian one. Same goes with patents. So you will not be able to protect your invention, your patent invention in Canada if it's not registered in the U.S.
Okay, great.
So you won't be able to protect it in the U.S. if it's not registered there.
Yep. And then follow up to that, kind of on that same topic, how do we protect our public brand and wording? Example, printed information, blogs, YouTube, website content from competitors using your wording, clips of your video, etc. So this client says we're soon venturing into growing our video channel, so she's wondering how to protect that.
So that sounds to me like it's a copyright issue if it's content that's on a website or it's video content or that sort of thing. And so copyright is a little bit different than the trademarks and the patent side, where copyright does sort of arise just from the fact of having created this content, and there's no real requirement that you register it in order for that copyright to subsist. And it's a little bit different also in the sense that if you're from a World Trade Organization country like Canada, once you get copyright, you automatically get copyright protection in all of those other WTO countries too. So it's a little bit different than the patent and trademark. So I guess how to protect it is there's really nothing you need to do to protect that copyright. It just sort of accrues just from having created the content. The other question, I guess the other side of that is if you find out somebody is taking your website content and just using it and copying it, or your videos or that sort of thing, to enforce your copyright, I think it's a whole other question, and I guess it would depend on what country this other party is using that material, and I think you'd probably have to go through the courts in that country. So I think the enforcement side is different, but the protection just sort of arises naturally.
Okay, great. And then a question here, can I patent a process? Example, I develop a new counseling technique or an exercise program. What do you do in the case of a proprietary process that you've created?
So processes are generally, I think they have to be more concrete. So for example, a gray area right now is even a computer implemented process or method, and whether that's sufficiently tangible to get patent protection rather than being, too abstract. One of the exclusions that we talked about is, or that didn't come up in our presentation, is if the process involves the skill of the person who would potentially be performing the process, then that's going to prevent it from being patentable. I think the argument being that it doesn't have utility because it's not completely reproducible from person to person. So it sounds like if this process is related to an exercise program, I mean, it would really come down to exactly what this process was. But I would think if the process was, say, for example, just performing a series of exercises in a certain way, like that might be considered too abstract and, would really depend on the skill of the person who's performing it, similar to, for example, a method of performing a surgery or something that has in Canada been determined not to be patentable either. It might be analogous to that and therefore not patentable. But again, these kind of questions are really fact specific, and they really come down to exactly what somebody is trying to get protection for, and it's really difficult, I guess, to answer conclusively, sort of in a general sense.
Yeah, okay. And we've got questions coming in fast and furious here. I know we're not going to have time to get to all of them today. So what I'll do is send these off to you after, and if you can provide some answers that we can send out to everybody listening today, that would be great. But I do want to close just with one question, final question here today. Before engaging lawyers or a law firm, what are the initial steps that an entrepreneur should take if they think they want to consider filing a patent?
So the first thing that we tell people to do, even when they do, after they do approach us, is they should do their own searches. So okay. Google patent. So if you go into Google and you type Google patent is a separate website, and it's a pretty good search. It's a pretty good resource. So I would use terms for what you think your new invention is, terms that are used in the industry, for example, plug those in and see what's out there. I would also do Google searches and look at scientific publications, but I would kind of just figure out what's already out there, and then based on that, figure out what you think is different about your invention and what the benefit is, and then I would go, and then that's when I would talk to a patent agent or lawyer.
Yeah, I mean, yeah, I think, definitely do the searches and also put your mind to what you think the important features of this are and try to kind of boil it down to maybe some, almost like a hierarchy of important features, and then that might maybe better focus your search to see if those features are known either in that particular technology space or maybe in a related technology space. And also that's going to help you with some of the considerations that we had talked about regarding, what's the competitive advantage that this patent is going to provide you. Getting patent protection is quite expensive, and, are those features worth that cost? And it's not only getting the patent that's expensive, but what are you going to do if you figure out down the line somebody, say Apple, for example, who has this huge war chest of money to fight patent lawsuits, it's going to be really millions of dollars to try to enforce this patent down the line, and is that a reasonable prospect for you? And if it's not, then if you can enforce the patent, then how valuable is it to you? Isn't it another consideration? I would say think hard about what's out there already. Can you get the patent, and what do you want to do with the patent?
Perfect, great. Well, thank you both, Todd and Michael, for sharing all this information with us today. We will send out a follow-up email to all the registrants today as well with more information and hopefully answers to a few of these additional questions. And we're excited to have BLG joining us again on Thursday, April 12th at 10 a.m. for the top 10 legal tips for new businesses. So this free webinar is going to provide an overview of best practices for new business owners, including tips for incorporating your business, deciding on your corporate structure, developing key corporate documents, navigating raising capital, and handling certain employment and tax issues. So to learn more about this webinar and other events, please be sure to sign up for our e-news and e-blasts on our website, womensenterprise.ca. So again, thank you, Todd and Michael. On behalf of WEC and all our participants, you've provided excellent content today and some answers to our questions, so thank you. And everyone watch for the follow-up email, and we hope to see you back here again on April 12th. Thanks, everyone, and have a great day.
Thank you.